So, as a part of week 3 lecture, we are going to discuss in detail some of the contemporary issues related to intellectual property rights. So, till now we have seen that how intellectual property rights are being globalized today. It has the global importance. Multinational companies are trying their best to get certain rights, certain intellectual property rights, because such rights are giving them monopoly power in the world. And we have seen that different types of intellectual property rights are available, and all these rights are having different nature of ownership, and they all are really contributing a different types of economic sentiment to the owners and to the consumers. After having such discussion, now we are trying to explore the current issues in contemporary intellectual property rights, and in this series, this particular lecture is talking about discussing about the contemporary issues in patents. So, to begin with, we will first try to give you the brief outline of this lecture. We will try to discuss the background of patent, again discussing the economics of patent. It is indeed important to link the patents with the genetic resources, the piracy which is going on, the patents in GM crops, GM food, patents in biotechnology, and one of the most important and challenging issue for a country today, which is pharmaceutical for the majority of the population in developing and least developed country, and then we will try to conclude. So, as we have discussed in detail, that patent system is the system which gives you which gives a firm a type of ownership which makes you very distinct and exclusive in the sense of marketing, and there are two distinct risks, internal and external, associated with the patent system. So, fair operation of patent system is the internal challenge for the economy. On the other side, the external threat is the execution of the patent system at the policy level, as well as the socio-economic impact associated with the patent system. So, a patent system, especially in developing world, is perceived by mistrust, doubt, and unrest today. And that is why it is called doubt and mistrust, because majority of the farmers, majority of the people associated with the cultivation, they are having this fear that whether the new patent system is going to really provide them any sense of security in their life or not, because there is a very slow occupational structure change among the farmers, especially in developing country and least developed country. And since majority of the population still is busy with the farming, and there isn't any other livelihood and other parallel source of subsistence for them, survival is really difficult for them. So, in that case, this patent system is becoming a challenging system, and lots of mistrust, doubts, and unrest is available. People are protesting against such a system in many developing countries. And again, the health is one of the major issue. Public health is another issue, and due to the increase of the diseases and the new types of diseases which is on the way, the R&D and the innovations in the pharmaceutical industry is providing a new challenge for the mass population. A challenge in the sense that the new medicines are really costly, and whether these low income group countries are in the position to, and the middle income group countries are in the position to really buy those products or not. So, due to these facts, and with this background, we will try to explore the different issues associated with the patent system. So, apart from that, we are also finding that there are multifaceted corners regarding the patent system. The negative impact ranges from the controversy that patents may be hampering the government's ability to deal with the policy issues, and the apprehensions about the awarding of patent protection to biotechnology and pharmaceutical patents may also hinder the access to the cheap life saving drugs, and concerns are also about the granting of false patents which unduly limit both the public sphere and competition. So, one of the issues which is related to the patent today is the genetic resources. Genetic resources are originating from the nature and thus cannot treat it as the creation of human intellect. So, they cannot be straightly protected by the intellectual property rights. It is true that there are intellectual property concerns related with the genetic resources today, and plant breeders' rights is the channel through which these plant varieties are developed using genetically resources products, and also which is patentable. So, granting of unfairly patent protection should be prevented which do not fulfill the prerequisites of originality and innovations of those inventions based on or developed using the genetic resources. So, unauthorized use should also be prevented, especially in genetic sector, and we find that there are large number of genetically modified foods which is patented these days. The major issue associated with GM food is the patent, because GM foods effects on health is not clear, but it is true that their consequences on farmers, scientists and the market is far reaching. So, the probable disadvantage of the patenting of the genetically modified organism are the threats that multinational corporations and companies can monopolize the food supply. And some of the issues which we have seen till now, that yes, there are chances of monopolizing the certain sectors including the food sector. And so, this patents of genetically modified crops is going to give us a new challenge, and this type of issue is the real issue for many developing and least developed countries, because all these crops are not produced by the small farmers or not produced by the general farmers in developing and least developed countries, but some of the multinational corporations like Monsanto and other MNCs in developed countries, they are really producing such crops, and they are really the breeders of such variety, and they are really trying to explore their market in many parts of the world today. So, one of the example today is the terminated genes or suicide seeds make sterile next generation plants and compel farmers to buy seeds for the next harvesting seasons. The utility patent protection unlocked the doors for multinational corporations like Monsanto to enter into the global seeds and pesticides business, and patents of seeds by MNCs prevent farmers to prevent patented seeds for the next crop season. And we have some of the cases related to Monsanto, and some of the news coming out that Monsanto is also challenging some of the farmers who has really kept certain seeds for preserving those seeds for the next crop. So, such examples are and such news are not giving us any good or any good feel to the developing countries farmers today, and this is one of the challenging issue in front of us. Apart from that, one cannot really miss to discuss the neem controversy related to India. The US Department of Agriculture and US MNC WR Grass were granted a European patent by the European Patent Office in 1994 on techniques to control fungal contamination in plants using a certain proportion that included the neem tree. So, the patent was this particular patent was protested by different groups from European Union and India in 2000, and why it was? Because the International Federation of Organic Agriculture Movement, the US Green Party and Bandhana Seva opposed this patent. In 2005 also the W.R. Grace filed the appeal, but lost the appeal. The natural properties of neem is well known to India and Nepal, and the patenting of the insecticides property of neem is an example of biopiracy and works over unjust claim and granting of patents to genetic reserves and traditional knowledge, which is also presented as TK. So, application and use of cell and molecular biology for the transformation, modification and enrichment of product or methods comes under biotechnology. On the one side, the current patent system has conferred intellectual property protection to innovation in biotechnology. However, on the other side, it has initiated confrontation of the interest of public and private parties. So, it is true that such innovations in biotechnology is helping us to really have high yield variety plants, and moving ahead in terms of the challenge which is on the way in terms of food security, or really helping those farmers which has low productivity problem due to the traditional seeds. But at the same time, it also created one of the challenge for the larger interest of the public and private parties, which were not supposed to, even some of the farmers who had the traditional mindset of preserving seeds and who were really having a free mindset to do the farming. Now they are really challenged due to the new set of rules or the new set of patented items, patented seeds which is available in the market. And the best part of these seeds are produced in a way, these seeds are prepared in a way that even if the farmers are allowed to keep those seeds, first thing is they are not allowed to keep, and the second thing is even if they are allowed to keep those seeds, nothing is going to be achieved for the farmers, because the seeds are developed in a way that even the farmers will preserve it, they will not be able to get anything out of that seeds because of the engineering, genetic engineering done with those seeds. So, there is a wide debate generated around the issue of patents of genetic material, either derived from the living beings or isolated from them. So, two diverse sets of arguments have been levelled. One argued that such biotechnology material are just discoveries and thus not novel to be patented. However, the other perceive it as the invention and argue in favor of patenting these materials. So, both the debate and argument is really in the news, and activists or some farmers allege that Monsanto and other companies have resorted to unfair patent protection to exploit the natural rights of farmers to save new seeds produced during yield. So, the parallel accusations have been levelled against Madrid Genetics, which is facing its own Supreme Court patent challenge. So, this shows that the issues related to the patent, especially in the GM food sector, is not new, and time to time these US based companies and other companies in developed countries are really work hard to grab the opportunity to patent certain knowledge, which is the traditional knowledge for if a group of farmers, or traditional knowledge for a generation to generation in country like India and other Himalayan region. Second best example may be the example of basmati rice. Rice Tech US based company patented certain cross breeds of basmati and half drop long grain rice in 1997. The patent was awarded by US Patent and Trademark Office, and the government of India interfered, and 3 of the 20 claims granted to Rice Tech were again challenged, And this type of example is not the example where we can say that it was just a single example, but we have another examples from India, that is the turmeric, Indian wheat, jasmine rice from Thailand, tomatin Western African product, chickpea seeds from India, colored cotton from South America, and many others. Other products are some of the few examples that became the victim of piracy today. So, Indira Gandhi Agriculture University in Chhattisgarh has collected some of the data that 2,600 varieties of rice were available in Chhattisgarh, but today it has declined from 2,600 to almost the level of 100. And Chhattisgarh Mukti Morcha once upon a time had a huge protest against the buy piracy going on from the Chhattisgarh region, because many scientists and many firms from outside world, they were trying to really collect the genes of different rice, and there was huge case of buy piracy from India. So, this type of examples, this type of cases gives us the idea that this has really elevated and led to massive protest by the resource rich countries against the malpractices of United States and the European Union. So, another issue which is equally important and challenging for the intellectual property right, especially for the patent system, is the pharmaceutical patents, which have increased the cost of essential and life saving drugs. This has created a barrier to access to the medicine, because price of new medicines, which is based on the level of R&D and innovation, is very high, and it is not so easy to really have such medicine on the low price, even if the government is interfering in providing certain subsidy, and it is not so easy for every government to provide certain subsidy. And it also depends on the size of the population which each country is having. So, country like India is one of the country which has to really get a very bad impact of such pharmaceutical patents, and ultimately we have many parts of world, especially Africa and Asia, are facing severe health hazards like HIV, AIDS, tuberculosis, malaria, and recently the influenza and swine flu. So, according to World Health Organization, more than 100 million people in the East Mediterranean region do not have access to medicine, and these are one of the challenging issue and task in front of the world community when we are really having the pharmaceutical patent as one of the example. So, the Doha Round, which is one of the most controversial round, and that included public health as one of the issue, that detrimental consequences of patent protection or patent misuse is dealt under the TRIPS agreement of the WTO. However, its use is not easy in order to check the barriers to access to the cheap medicine. So, in 2001, the 4th WTO Ministerial Conference was commenced in Doha and approved declaration on TRIPS and public health, and national governments can take measures for protecting public health by the means of compulsory licensing. So, this compulsory licensing is in compulsory licensing, the government permits third party to manufacture the patented products without the approval of the owner of the patent. Doha Declaration underlines the grounds on which the compulsory licenses are awarded by the members, and they are free to do so, but the duration of the transition period for the adoption of the TRIPS agreements, TRIPS commitments, were increased from 2006 to 2016 for the least developed countries by the Doha Round. So, this year is the last year of that waiver for the least developed countries. However, it did not resolve all the issues related with the patent protection and public health. So, as a part of the conclusion, patents on the one hand promotes R&D, and on the other side grants monopoly powers in the hand of big corporations in the developed world, because the country which has more investment capacity, they are again a great investors in R&D and innovations. So, the problem becomes severe when there is a fraudulent patents filed and granted by the authorities. We have seen in case of basmati rice, and we have seen the case of neem, where certain authorities has granted patent rights. But the point is, it is not one case, but there are large number of cases of biopiracy, piracy of traditional knowledge today, and pharmaceutical patents are again one of the major issue. So, when we talk about the patent, certain issues which is connected to the day to day life and the mass population cannot be ignored. It is true that Doha Round has taken care of certain issues related to public health, but it is also true that in the current framework of the new patent rights, developing and least developed countries are not really equipped enough to fight with the local issues in health and diseases which really puts government into the crisis. So, in such a situation, it is important to really have a very comprehensive exercise done by these developing and least developed countries to counter the new patent system. So, this is one of the discussion which I wanted to have it on the issues related to the contemporary issues related to patent. I hope these readings will help you to understand more about the current issues related to intellectual property, especially the patent rights. Thank you.